welcome to our day 2 of our OMB webinar series, Mitigating Life's Pitfalls, Wealth Protection for Business Owners. There are seminars being run all week, so please do go onto the Milton Reeve website and sign up to any of the webinars if they are of any interest. And I will swiftly pass over to Katherine to introduce the session. Katherine.
Thanks very much, Andy, and thanks everybody for joining us today. So just a quick agenda to start with. We're going to look at how the law is applied to the division of finances on relationship breakdown, so that you can understand why wealth protection is important for business owners. Then you'll see a quick checklist for every owner-managed business you may be working with or in, and we'll explore some of the issues there. And finally, we'll explore some measures that you can take to protect wealth, to protect business assets. Although a caveat to that, so early on in the presentation, I hear you say, but there we are, I'm a lawyer. Businesses and personal wealth are structured for all sorts of different reasons. For tax efficiency, for succession, sorting out succession plans, inheritance planning, and of course also wealth protection on relationship breakdown or divorce. You are unlikely to be able to tick all of the boxes all of the time for all of those scenarios. So really it's all about awareness. That's the key takeaway. And then listen to what we say today. You can decide where your priorities lie and then act accordingly. Okay, so when a married couple separates and they have to sort out their finances, we're governed by statute, Matrimonial Causes Act 1973. Many of you may be familiar with this, and in particular what we know as the Section 25 factors. So things like how long have you been married for? How long have you been living together before marriage? Many people don't realise that if you've been living together for a period of time, so you live together for 10 years, then you decide to get married and separate 3 years later. That's not a 3-year marriage, it's a 13-year marriage. And all of those assets built up during that pre-marriage period of living together can be looked at in great detail by court. So how long the marriage is, how long people were living together, moving seamlessly into marriage, things like the age of the parties, their financial resources, their earning capacity. Earning capacity has a knock-on effect, of course, on mortgage capacity, which again, it impacts on housing needs, how much capital do you need to house, etc. Standard of living, we try and maintain the standard of living so far as we reasonably can. Although often it does require a step down for everybody. A look at contributions. It's another Section 25 factor. Who's contributed to the marriage. Very often it's a marriage of equal contributions, but there may be assets that have been brought in that have been in a family or one side of the family for many generations, and people can seek to try and retain that for the benefit of one side of the family. Also under the Matrimonial Causes Act, the court has a variety of powers and orders that can be made in relation to financial matters, including power to transfer property. And that includes orders to transfer shareholdings. Now, that doesn't happen often, and certainly not often in terms of being imposed on people. So it's not popular, but it is an option. And I've certainly dealt with that sort of outcome, transfer of shareholding, for the right case. Generally, in my experience, where there's a degree of trust and mutual respect, it can be helpful to receive a dividend income from a shareholding, and you put appropriate arrangements in place with shareholders' agreements and things like that. The court also has the power to order a sale of property. That's not just houses and assets like that. They could compel the sale of an owner-managed business. Again, very rare in practice. It's going to be to everybody's benefit generally to see a successful business, no fire sale, and everybody's likely to benefit more from a planned sale if there is to be one in the future. And you generally don't want to sell the goose that lays the golden eggs, but it can be a threat that hovers over cases. And the court has wide-ranging powers. So really all options can be on the table in cases, and all options in relation to businesses to try and achieve a fair outcome for everybody. I would like to share a quote from a judge, which is that one of the frustrations of family law, perhaps with some practitioners as well and those involved, as well as one of its fascinations, is that no two cases are ever the same, and the concept of fairness becomes a matter of judgment. This is a reference really to the uncertainty of the application of those Section 25 factors. And of course, one person's fairness never equates with another's. So, it's very difficult sometimes to reach outcomes that everybody feels are the right one for them. So I'm just going to pass back to Andy to look a bit more at the application of that statute to cases involving businesses.
Thanks, Katherine. So the starting point for all cases is those Section 25 factors, which Katherine mentioned. And case law only takes cases so far, and you can find a case which supports your argument. But it is the Section 25 factors which is a key component of a judge's decision making. But there are a few cases from the last 20 years or so which have really shaped the law as we find it now, which accentuates the requirement and the need to have some wealth protection in place. So let's jump in. So the case of White in 2001, before that case came along, you had the business owner retaining the vast majority of their assets on any divorce, and the weaker financial party, most often the wife, just having their reasonable requirements met. But in the case of White, they introduced the principle that there shouldn't be any discrimination between the homemaker and the breadwinner, and this idea of a yardstick of equality. Now, it didn't start a principle of equal division, but it made some major steps in that direction. Fast forward, Miller and Macfarlane in 2006. Now, this was a conjoined appeal before the House of Lords, as it was, the Supreme Court as it is now, where the judges in that case said to actually arrive at a fair, objectively fair outcome, you have to consider the elements of needs, compensation, and sharing in every single case. The needs in the Section 25 factors, that's nothing new, although it's to be generously interpreted rather than just needs. Compensation, because of some relationship disadvantage, it is a key consideration, although has rarely been argued successfully since. But for the example from Macfarlane, for example, was a city lawyer who had stepped away from her job to look after the family, and upon separation, her earning capacity was far less than it would have been had they not got married. And again, accentuating this idea about sharing. So in Miller and Macfarlane, the idea of sharing and a yardstick of equality was an aid rather than a principle, so it's still not a definite outcome. But I'm sure Katherine will agree, in our experience, for medium to long marriages, the starting point and normally the ending point probably is sharing of the marital partnership and the assets that have been amassed. Slightly changing the dial in terms of outcomes was Sharman in 2007. Now, I think this is a case which probably has been decided and will be kept to its facts, because it was the biggest contested court hearing in up to 2007, with £130 million in it. And in that case, the court said, well, actually some special or stellar contribution could mean that you move away from equal sharing. In that case, the business owner retaining over 60% of his assets, but that would have been a lot less he would have retained a lot more pre-White, or had he had a prenup in place. So what do we know from business cases, and why is it important for wealth protection to be considered? The first thing is the family courts do respect the separate legal personality of companies, so they don't go and start transferring assets from businesses owned by businesses to third parties or spouses, unless in very limited circumstances. The court can order disclosure of company documentation, even if the company is not a party to the proceedings, although normally if you have a husband and wife going through a financial remedy application, and a business is a feature, then one of them probably is a shareholder and director, and they can provide those documents by virtue of those roles in any event. The courts, in the vast majority of cases, will want a valuation of the business, and that will be undertaken by a single joint expert. They want to know what the current value is. It might be the case that they look at past or future value as well. And they also want to know what sustainable income there is to pay maintenance moving forwards, perhaps, and also liquidity to fund a settlement now, and how it should be reflected in any financial distribution. So that kind of then leaves the court with what options they need to consider. The first is sale. Now they are rare, but I do have one on my books at the moment. So I've just been instructed by a wife who, in a previous case many years ago, had a court order saying that every single property and a company should be sold by way of the instruction of a receiver, and everything divided 50-50. Now, post that court hearing, husband and wife probably felt that was a little bit draconian. So business owner husband was given some time to actually raise the money, but he hasn't paid up. So I'm now making an application to the court for a receiver to be instructed again to sell as much of those properties and companies as is required to ensure that the £2 million or so that's outstanding is paid. The court can transfer shareholdings, as Katherine mentioned. It's more often a tool when one of the spouses is already a shareholder, or maybe more of a minority shareholder at that point in time, but the court has got the power to do it. But they also appreciate that it's difficult to protect minority shareholders, and unless it is done on a consensual basis, and you have drag and tag rights implemented in there, you have proper shareholders agreements to protect that minority shareholding moving forwards, then it probably is more of a last resort. An approach which links to transfer of shareholdings is what we call wells and wells sharing, which is dividing assets in species, so sharing those risky and illiquid assets, which would normally be the business, equally, and also sharing the liquid and less risky assets, such as cash in bank or the home, for example, equally, so both parties have got the same platform moving forwards. That's certainly an option. But in the vast majority of cases, subject to being enough non-business assets, you normally find that there's an offsetting arrangement. So maybe the business owner retains his business, maybe at a discount because it is riskier or illiquid, or is far more focused on a future income source, and that's offset with the non-business spouse retaining more of non-business assets. But I'll pass back over to Katherine.
Great, thanks, Andy. So you've had an overview really of how financial matters can be dealt with on divorce, the sharing principle, the discretion of the court, needs, etc. What do we tend to do then when we advise those seeking to protect their business assets, their overall wealth? And it's difficult to say, but it's the reality. If we're acting for the wealthier individual, the wealthier party, the advice tends to be, you don't get married. But that's not very romantic. It doesn't really reflect life, day-to-day life for most people still, in fact. But that is the advice. Because for those who are not married, their claims are really very limited. They're limited to strict property interests, complicated trusts and land law, separate claims that can be made for the children under Schedule 1 of the Children Act. Not time to explore in great detail today. But there's no sharing. There's no sharing of the marital bequest. There's no sharing of the business that's been built up during the marriage, the relationship, as there could be, in a marriage situation. We still get disputes, of course, and they can arise in relation to business interests between cohabiting couples who are separating, and partnerships. And of course, if they're more formally involved in business together, perhaps if they're 50-50 shareholders in a business, and they're both directors, you can get into a deadlock position quite quickly. So it's really, really important in these sorts of situations to always think about mechanisms that you can write down and agree in advance to sort out disputes in the future. Perhaps one of a couple maybe works for a business informally, perhaps they've been promised an ability to share the fruits of their labour in the future. Perhaps one of a couple's made a financial contribution, need to purchase business premises or something like that. Maybe the relationship, although a cohabiting one now, may move seamlessly into marriage. So we've got sort of assets there that may form part of a marital bequest in due course. You'll see on the screen a sort of noddy note on how various interests can be established by way of constructive resulting trust and proprietary estoppel. And it should really come as no surprise to hear that often those sorts of claims arising out of cohabiting relationships, when they break down, are really sometimes very difficult to argue, very costly litigation. And much of it can be based on who said what to whom and when. and you are literally sometimes trailing through text messages, WhatsApp messages, these sorts of things to try and understand what evidence there is as the common intention, what evidence there is as to promises made, etc. And then facing some perhaps risky oral evidence if the matter proceeds to a final court hearing. And judges aren't necessarily asked to decide, or they don't necessarily decide solely on the evidence as to what everybody individually intended. They can actually impute, they can impose an intention that neither of them really had as a matter of fact, but which the judge views as reasonable to impute given the course of conduct between them. So it's so important to make sure that there are contemporaneous written documents to support intentions here. Board minutes can be really helpful. Contemporaneous written business plans can be really helpful. That can be difficult in terms of establishing values, because sometimes you prepare business plans in order to raise funds, perhaps for a fledgling business, that you can overestimate the value in reality. So they could be quite optimistic forecasts. Cohabitation agreements we'll come on to mention a bit later. In fact, and if we move on to the checklist, I know cohabitation agreements are there on that checklist. Thanks. So if you're going to screenshot anything, this may be a useful summary of the things that you need to think about for owner-managed businesses. And in fact, I'll hand over to Andy, who's going to have a look at number 1 on this checklist, the company structure and documentation that can be really helpful when we're looking at business and finances on divorce.
Thank you, Catherine. So the first point to consider, so we're now into wealth protection rather than what are the dangers of relationships and involving family members within the business. So we are focusing on wealth protection now. So the first thing is what can you do? The first thing would be to have a company structure, probably. As I said previously, the courts do respect the separate legal personality of businesses. If you are holding assets as a sole trader or a partner in a partnership, then it does make it easier for the courts to transfer or sell property and assets that you have. So companies are a way to go still. Governance, make sure you've got articles of association and your shareholders agreements are in place, and make sure they evolve with the business over time. And consider what needs to be in them. Preemption rights and first refusal on share transfers. Now, I'm sure if you have those in your company documentation, the court will even be less likely to try and attempt to transfer shareholdings to a spouse if they know that the company can simply not register that shareholding at all. Valuation mechanisms, maybe that's a part of the preemption right. So actually, if the shares need to be valued as a part of the process, or to buy the shares off the spouse who might receive them, but there is a valuation mechanism in place to ensure that they are bought for a value which is commensurate and something appropriate for the company. Casting votes and dispute resolution, you don't want to have a situation where you have family members or other shareholders within an OMB structure who can create stalemate or stop the company functioning as it should be. And if that was to arise, think about options around dispute resolution, whether it's arbitration or mediation, for example, to bring about swift outcomes and not be deadlocked, which has an impact on the company. And also think about anti-competition provisions. They might be in shareholders agreements, they might be in employment contracts. But what you don't want to have is trusted employees, even family members, setting up on their own outside of the OMB and being in direct competition with the family business. You've also got to consider why you need to have a family member as a shareholder or employed in the business at all. And I completely get that it is tax efficient to have members of the family in the business and being able to distribute what would be family wealth through dividends and PAYE, for example, through the business structure. But it does come with its own problems. And I think Catherine and my job would be a lot easier if actually people didn't involve family members within the business. But if they are going to be involved, maybe keep it just to lineal descendants rather than spouses. Or if you want to involve wider family, have a think about, well, what can we do around shareholdings? Can we have different voting rights for different classes of shares, and the same for economic rights as well. So the business owner, the true business owner, the person who is pushing this company forward, has got some control over the future of the business when it comes to voting and distribution of profits, for example. Katherine.
Many thanks, Andy. So just a quick look at family constitutions. Again, documents and ways of arranging family owner managed business which involve family members, which can be helpful in the future as well. What is a family constitution? Well, it's a formal document, and it records and it articulates the core family values, their goals, their long-term strategies for the business. And it can establish a forum for decision making, so calling family meetings from time to time. It can set out rules on transfer of shares, how votes can be exercised. It can set out what each family member can expect to receive. Sometimes it's easier to have those open discussions. Everybody knows where they stand in advance. And again, as mentioned by Andy, perhaps give clarity that shares pass solely down, to lineal descendants, which can be quite protective. It can provide also for the shared common intention that family members, as they get married, enter into nuptial agreements, or as they live with someone, enter into cohabitation agreements. And if that's already been discussed well in advance, it's really, really helpful because it can normalise that process. So it doesn't come as a surprise to anybody. And of course, it makes it much easier sometimes for the individual presenting the idea of a nuptial agreement, a prenup, or a cohabitation agreement, to explain that to their partner in the context of, well, this is something the family have always done, and we agreed we always would do. So it can be useful for that reason, from the family law perspective. You can provide for ways of dealing with disputes. So you can move people towards arbitration, for example, which can be really helpful, and particularly if we're resolving family matters. Privacy can be very, very important for many of our clients, and courts are moving towards a little bit towards sort of an open justice position. You don't want to be in court where you could be under a degree of public scrutiny in the future. Arbitration is very much a private process. So those sorts of mechanisms can be really helpful. Whilst the family constitution may not be legally binding strictly, it can be enforced by replicating or repeating the issues you've decided upon and agreed upon in a shareholders agreement, as Andy mentioned previously. So these can be really helpful. So remembering that on a divorce, judges have complete discretion to reallocate assets, including shares, including interest in companies, business premises, directors' loan accounts, DLAs, cash, income stream, etc. They've all been reallocated, sold to achieve fair outcomes, or fair, somebody's perception of fairness in matrimonial proceedings. And is going to have a look at some of the protective measures that you can put in place.
Okay, so nuptial agreement. The first thing is these are for everyone, not just the super rich. So you have, they're really useful for second marriages where someone wants to leave their assets to their children from that previous marriage, but also for business people, and that's a key part of the work that both Katherine and I do. It's also worth considering that they could be signed before and after marriage. So if you have a situation where you're looking to put some planning in place for the next generation, but half the next generation are already married, then you can still put the same level of protection in place, just with slightly different wording, and have pre and post nuptial agreements. So what's the current situation of nuptial agreements in front of the courts? Well, they are given substantial weight, but we still can't oust the jurisdiction of the court. So if needs aren't being met, so those reasonable requirements which pre-White the court had, then the court will have to invade those assets covered by the nuptial agreement to the extent required, but it certainly wouldn't jettison the rest of the agreement. So they are hugely useful in protecting wealth moving forwards. in that they do help to minimize financial and emotional impact in the event of divorce. And what we need to do is, and something which Katherine mentioned about normalizing these things, is actually we need to move away in this country from them being very Hollywood or unromantic, because all over the world, people are putting nuptial agreements in place. For example, in continental Europe, you have to elect a property regime as you're about to get married, which dictates how you hold your assets both on marriage and in divorce. In Scotland, you might feel you don't have to have a nuptial agreement because they ring-fence premarital wealth and inheritance that you receive during the marriage. So there's a starting point of protecting wealth, which actually most people, Joe Bloggs, would think is protected anyway, which we simply don't have in this country, since White and White in particular. So what do we need to do to have a nuptial agreement? They need to be freely entered into. So I'm afraid we can't put people under duress, make threats. People enter into them by mistake or misrepresentation, and they have to have a form of being in a deed and at least signed off 28 days before the wedding. If you miss that deadline, you can still put it into a post-nuptial agreement afterwards if required. People entering into prenuptial agreements need to do so with a full appreciation of the implications. That means limited financial disclosure, nothing like you'd have to do on a divorce, and also separate legal advice as well. And again, they have to be fair to hold the parties to their agreement, but ultimately the courts are not wanting to be overly paternalistic here and dictate what their idea of fairness is. What is the idea of fairness that this couple has, and make sure critically that needs are being met. So what are the true benefits of nuptial agreements for businesses? So first and foremost, protect those shareholdings from sale and transfer. I see business owners coming in all the time, and I've got a number on my books at the moment, who are their businesses are being impacted all the time by the fact they do not have an outcome, and the business is either putting innovation or investment on the back burner because perhaps they maybe don't want to share that growth in the future upon any divorce. Or perhaps they think, well, I need to keep some liquidity within the business to fund the settlement in the future. And again, the eye is being taken off the true business work that it wants to be doing. A great benefit of having a prenuptial agreement, if you're wanting to re-fence some pre-marriage value in that business, particularly important for established businesses, is you can actually have a line in the sand and say, well, what the business is worth at the time that you marry. And it's probably the only time that we have business owners being overly optimistic about the value of their business, because on divorce, it's all pessimism. Those contracts aren't going to be replaced, and the focus is very much on damage limitation rather than now supporting the marriage to come. Huge plus points: less input needed by the financial director or company accountant having to field questions from the court or both parties to the divorce, and less legal spend and external accountancy spend as well, when you're focusing on those reasonable needs rather than full valuation of all assets and a division for division's sake. You can plan for the next generation with more certainty as well. I've done prenups for two brothers who in the future will receive the vast majority of their father's shareholding in the family business. They're agreeing to share absolutely everything from their marriage equally with their spouses. But there was a focus on the generation above, that if shares were going to be cascading down to future generations, that they should be protected at all costs from any future divorce. And with a divorce rate beyond 40% of all marriages, it is something which you should insure against if you can. And finally, some pre-agreed agreements around resignation or conduct of spouses. Is there one party who should leave the business, take a step back, not come into the office to make sure that people aren't caught in the crossfire? These sort of agreements can, have those predetermined agreements to make it a bit easier if it was to happen in the future. And I'll pass back to Katherine.
Thanks very much, Andy. So just very quickly touching on cohabitation agreements. These are agreements that are entered into by a couple who are living together or going to be living together, and particularly useful actually, or perhaps particularly highlighted or used where somebody may be moving into somebody else's property, or they're going to be buying a property together, perhaps in unequal shares, and they just want to regulate, make it clear who owns what. They're less common than nuptial agreements, anecdotally, I feel, possibly because people sort of can easily drift into living together. You spend more and more nights at one another's properties, and then suddenly you're living together. So it could be for that reason, or it may, of course, be because marriage imposes rights and obligations. We've seen that cohabitation currently, and in any event, just doesn't. But they can be really helpful documents in terms of evidencing, again, in writing, the joint common intention of the couple. And that can reduce their ability to raise arguments later about gaining interests in a business or business assets, by way of those trusts we saw earlier, resulting trusts or constructive trusts, or where there's involvement in a business. It can provide for outcomes if the relationship were to break down, or mechanisms for items to be returned to a company if they belong to the company, cars or things like that. Or agreements to resign, etc., those sorts of things. I need to take employment advice alongside that, of course. So please do bear those in mind as well for the appropriate situation. They can be really, really helpful documents again. I then just want to move on to ways of resolving issues, if I may. Litigation clearly is something that all lawyers are well practiced at. It's what we do day in, day out. But it's really, really very hard for clients, actually, litigation. It's high cost, both emotionally and financially, and the outcomes are not always certain. So we must really always try and encourage litigation to be sort of a last resort for family law matters in any event. And there's lots and lots of ways of resolving issues and disputes between couples, far more available to couples now than there ever were before, which is the right thing for family law disputes, no doubt about that. I'm a mediator, and as a mediator, so can mediate matters. You put a different hat on altogether. As a mediator, you don't give advice, you give information to a couple together, and you try and facilitate their discussions together to try and resolve matters. There can be huge benefit to that. It doesn't polarize couples. If there are children involved, the outcomes tend to be more positive. Lots of reasons to think about mediation in relation to businesses in particular. Again, Andy mentioned this. Litigation can be very long. It can take quite a long time. And during that period of time, a business owner is preoccupied very often with the divorce and sorting out finances. It is really very difficult for them to focus on building the business, making the business work day to day. They may have been working very, very long hours running their own business. It is very difficult to keep that focus when you are going through family proceedings. So mediation is a really good way of trying to resolve matters constructively and enabling the person working the business to get back to it and to move on. And actually that works for everybody, generally speaking. You've got collaborative law, which is when you instruct lawyers and all sign up to a process that keeps you out of court. If any of you end up in court, you sack your lawyers effectively and start all over again. So everybody's got an incentive to really resolve matters round the table, not through correspondence ping-ponging. You've got other options available. You've got arbitration, which I think has been mentioned several times through this presentation. It's sort of like a private court almost. Again, avoids huge delays. And you get a binding result, and particularly useful if there's one aspect perhaps that a couple can't agree on, maybe related to a business that you can't agree on. You can arbitrate that particular issue and get an outcome that suits everybody quicker perhaps than through court proceedings. You've also got FDRs on that slide in front of you. Financial dispute resolution hearing is something that you end up at if you go through the court process. It's the middle hearing, it's a negotiation hearing. But again, it can take time to get there, or we are finding you have a risk of finding out on the eve of your hearing that it's not going ahead because of court capacity issues, etc. You can have private FDRs where you have a barrister who sits as a judge effectively, and they work fantastic. Of course, it's almost like the Bupa of law, I call it, but they work so well in my experience because you know you've got that judge for a whole day. You know they've looked at the papers in advance. You have fairly good conditions in terms of being able to have private rooms to have conversations during that process. It can work fantastically well. And we've introduced separating well with one lawyer at Mills and Reeve. Another opportunity. It won't suit every couple, but it certainly suits some where they already have a sort of common goal in mind, common intentions. Can be really, really helpful. So please do not dismiss appropriate dispute resolution. Used to be known as alternative. Appropriate, I've always found, is a better word for it. All of those options on that slide give clients a greater level of autonomy, actually, a greater ability to craft outcomes that simply might not be seen in the court process. And so with that approach, with the correct approach for each client, whether it's before divorce, during the process, you can safeguard interests in businesses, for example, and you can get a negotiated deal within a reasonable time frame, and you can leave that business to thrive and that entrepreneur to move on without the stress over them of the litigation, and concentrate their energies on the business rather than what really is really difficult process otherwise for clients. I think sometimes we ask miracles of them to carry on their sort of day-to-day business life while divorce is looming over them. So that's it for today. We are very happy if you want to get in touch with either myself or Andy with any questions. There is also a seminar. The seminars every day this week. Tomorrow there's a seminar on managing your business with my colleagues James Hunter, Deborah Clark and Alex Kenworthy. Is more of a panel discussion, I think. Have a look at our website for details of that. We're a little bit over time, but thank you very much, everybody, for joining us today. And as I say, do just link in using the codes there if you want to with us, and ping an email if you have any queries. Very happy to answer them. Andy, do you have anything to add?
I don't. Thank you very much, everyone, for joining us, and look forward to seeing some of you in person or online soon. Take care.
Thanks very much, everyone.